Daily list, item number 1 for admission, Carter.
Yes, madam, did you get anybody?
Lordships, I unfortunately could not procure any name, but I've just been informed that my learned friend, he was here just a while ago, Mr. Gogoi. He has managed to get a private practitioner's name, a lady doctor who is, I think, working in downtown hospital. I have no difficulties if that lady is appointed as the district. Also, I was also just informed that Ms. MD Bora, the advocate here, her husband is also a pediatrician. I just got the news. I was not aware of this. I had, in case your lordship wants another name, then
That's okay.
if Mr. Gogoi has a name, then I have noted.
One name, my lord, has been furnished by the DME. She is a senior pediatrician, and she has consented otherwise. And so far as a particular room is concerned, my lord, DME will accommodate one room if lordship direct. And my lord, regarding one PA or someone, my lord, to take dictations and all, their lordship may indicate they will accommodate.
Secretarial service.
Secretarial, yes, particular.
Okay. And
But,
how much have you thought about the honorarium?
That I leave it to your lordship.
Normally,
Personally, I
how
government
it
to pay, my lord.
How much is normally given?
Honorarium is an honorarium.
But then also
I do
it
not
is-
know, your lordship. They are very, like I said, these people are very highly paid doctors. We can perhaps never be able to touch their this thing, but perhaps
They will help otherwise, but some
10, 15,000 per
Fine.
perhaps 15,000 per person.
make 25 then honorarium to each person.
lordship.
And secretarial assistance of around how much? So there will be a time for the report also, no?
Yes.
Secretarial expense, how much?
Have to be my lord, less than.
It will be secretarial expenses, secretarial services you will be giving from your office, then not necessary.
Yes. That lordship may indicate, my lord, either from the, if they provide from the office, then my lord, it's not necessary. Otherwise, privately, if somebody is engaged, then someone, they will have to pay for it.
No, I don't want that any amount should go from their own pocket for their secretarial expenses.
No.
So that
That
is
lordship will
why-
indicate. The government will pay otherwise. Either day, my lord,
And I will say the secretarial
They arrange.
expenses will be paid by the government.
Right.
Either they will provide the secretarial assistance
Yes.
or pay whatever amount.
if a secretary is engaged by the doctors, my lord, then my lord, the government will pay. Otherwise, government may accommodate one.
Okay. I'll pass the order today.
Lordship.
I'll give it that.
Yes, I will
We
give a
will
type copy
have
of the
one,
name.
we have Dr. Kyle or Dr. Bopatuki.
That I leave it to.
I will leave it to your lordship.
Tell me,
Otherwise, my lord, Dr.
Dr.
Ashok
Kyle
Kyle
is a
is
senior
a senior
person.
one.
Senior person, yes.
I think he will be
And
have Dr. Kyle and
Rasna Das Hazarika, she is also a senior citizen. Otherwise,
so
a reputed
kindly
one.
give me the
Yes,
details,
by
yeah.
including email, I will provide.
Lordship, could be fixing a date for the commission to sit.
For submitting the report by 2 months. Oh, because
Yes,
you see,
yes,
you
time
have to
will
appear. You have to appear before them.
The child, your lordship.
No,
Not the
I'm not.
child.
It is only on the question.
Right.
You are to show because, madam, you see, this court otherwise earlier wanted to pass, could have passed the order only without taking into account the question of negligence. Now, the aspect of negligence, this court either at that point of time was of the opinion that let it be relegated back to the civil court. But taking into account that the matter has been pending from 2014, it would not be proper. And it will require medical expertise on this aspect. And as such, this is only this aspect as to whether there was a medical negligence to that effect is to be decided. You don't need, because all other reports are already there. So on the basis of that, you just produce, because they are not going to
So,
go and check this the child.
Lordship wants us to appear before the commission.
Yes.
in that case, Lordship, perhaps make it clear in the order at
Yes,
the terms of reference of the committee as
yes.
to what would be their.
Yes, sir.
Because I was under the impression that perhaps child might have to be brought.
No,
I
no,
was,
it is not required because
that's fine. No,
you are
no
to just
difference.
show. Yes,
No difference.
if it was done on 14th, the thing would have been different. That is the only negligence.
Well,
Otherwise, there is nothing else thereafter.
Lordship.
Because they have taken on 16, and whether there has been any further you want to put the terms of reference, just give it to me during the course of the day. Just
I do not
you
have
may
to,
just suggest.
just
may just
because
suggest during-
I was under the impression that perhaps the child might have to be
No,
brought
no,
and
not necessary.
examined. If that is not the case, then simply that the fact
It's
that
it's
as per
purely a
limited facts,
question of
Then
question
there's
of
no-
determination on the materials which are there.
Correct.
The time the aspect as regards the terms of reference, you may just have a word with both of you and just give it to me during the course of the day. I'll pass the order to itself.
Lordship may also reflect that, my lord, they will have the authority to call for any, my lord, employee of the health department who was connected to this case, and, my lord, they can examine, including the nurse and all that. Otherwise, my lord, they are professional doctors, they won't be, my lord, knowing all this procedure. Only indicating that, my lord, they will have the power to do that.
Oh.
According to
That
statement and
will-
all.
Don't worry. You just give me a term of reference. Both of you decide what will be the terms you think. Then I will formulate. What's the order?
Lordship, 2, if we come back to your
Just give it to him also. During the course, because in the evening only I can pass the order.
notice. Deeply obliged.
Item number 2.
And here I prefer some further time, my lord. Instruction is awaited on the additional affidavit.
The partner matter.
Yes. No, not partner.
Not partner.
The third one length, my lord.
But it was hard at length.
Why did people have put it as partner? I don't understand.
So let it be partnered, my lord. Lord.
Why?
They post it on.
It doesn't
No,
work.
already, my lord, the issue is, my lord.
You know
Well,
one
well-
thing. At the end of the day, there is a particular list which comes up, which is being sent. One is a column how much disposed of, how many cases disposed of, CAV done, partner, all these things are correct. Let's say why should it reflect on that? It is not a partner.
But since your lordship had heard it at length, lord,
Yes, that may be reflected.
so your lordship will still keep it as partner.
Mr. Doctor, all matters I hear it at length only. That is why I'm slow and always finish around 5 o'clock in the evening.
On 10th, my lord, it's not inconvenient, my lord.
Oh, I remember. This
Yeah.
is the case.
Transfer.
As to whether that particular person, there were 3 doctors. No,
Yes.
Yes. Five,
Yes.
five doctors.
no, there were 5 doctors. He said 3.
He said,
You have come up with the fact that there were 5 doctors, of which 3 have been there for the last 15 years.
more than
15 years. That is the case.
Yes.
Okay.
On 10th, my lord.
Hmm?
On 10th. Because that instruction is awaited.
There's a stay, na?
Yes, these are otherwise protected.
No, we can't have it on 10th. No, sorry.
Fine.
You are still there?
Yes.
No problem with that. We'll have it later on because we have given you earlier also
Yes,
opportunities out there.
My lord.
So we'll
On
have to only
21st,
after vacation on
21st,
20
20.
or 27. Which one?
Let it be 27 in that case, man.
27.
Heard Mr. S. Dr. Dalanet Senior Counsel assisted by
S.H. Ram.
huh?
S.H. Ram.
S.H. Raman, the learned counsel for the petitioner, and Mr. B. Gogoi appears on behalf of the respondent, Family Welfare Department. Mr. B. Gogoi, the learned counsel, again have sought for an accommodation in the matter on the ground of want of instructions taking into account the same, let the matter be listed on 27th of April 2023. In the case the respondent family health and family welfare department wishes to file the affidavit for which the accommodation is sought, the said affidavit has to be filed by 21st of April 2023. Interim order passed earlier shall continue till the disposal of the petition.
Public.
Published.
At number 3,
Teacher lordship.
Hmm.
Lordship, on the last occasion, respondents were
Lordship, here
directed.
the petitioner has been accommodated as teacher with prospect to the effect, Lordship,
2020.
2020.
Ah,
The appointment letter is out.
he has joined.
Lordship, such a not yet reached.
What?
We could not communicate the client. Lordship.
Then what to do? You have accepted.
Lordship,
Why haven't you been able to communicate with the client? They are not interested.
no, they are interested, but
Then
the,
why is it that you have not been able to communicate?
the phone number that they have given previously. Lordship.
That means you have not communicated with them for a long time.
6 months or so.
The last 6 months, what was the status? Last 6 months, what was the status then?
They were receiving salaries. Lordship. They were receiving salaries. Lordship. That
Meaning
was the-
thereby earlier those people were not receiving. That means he has joined. Isn't it your case that you didn't receive your salary?
Lordship.
How did he receive the salary? Is because this order is passed on January 2021. And 6 months you have, if you have done so, then obviously they are receiving salary means they have joined this.
They have joined.
There's nothing
At
else.
sick pay they have receiving. They are
Yeah.
receiving the salary.
They are receiving only by dint of this. Earlier they were never not getting any salary.
Lordship.
Heard Mr.
P board Lordship.
P. Bottler, the learned counsel appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the Elementary Education Department. Mr. Barpujari, you are appearing. Mr. R. Barpujari appears on behalf of the Finance Department. The instant writ petition has been filed by the petitioner claiming ADS salary. It has been brought to the attention of this court by Mr. P. N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department that in pursuance to the decision of in pursuance to the decision of the cabinet, a one-time exercise was carried out by which various persons whose appointment were found to be irregular or illegal were regularized to the services of the government. And they were given on the condition that they would be accommodated purely personal in nature, and the post in a post permanent purely personal in nature, and the same would cease to exist as and when the incumbent retires from service or expires. It is also one of the conditions mentioned in the policy that the said person has to, the said employee has to also, said incumbent has to also forego all their claims, oblique benefits whatsoever in respect to their past service rendered by him or her prior to 1/11/2020. The learned counsel appearing on behalf of the respondent Elementary Education Department submits that in pursuance to the said policy, the petitioner herein was appointed as a tutor by an order dated 30/1/2021 And as per his information, the petitioner have duly joined the said service. On the other hand, Mr. P. Bodloy, the learned counsel appearing on behalf of the petitioner, submits that although he has not been able to contact them, him or her,
Her.
her, in recent past, but 6 months back, when he had contacted, she had said that she had given instructions to him to the effect that she is being receiving salaries. Taking into account the submissions made by the learned counsel for the party and the fact that the petitioner have already been appointed as a tutor, and while accepting the said appointment have duly foregone all the claims of like benefits in respect to the past service, the question of the area salary as sought for in the instant writ petition cannot arise. Under such circumstances, the instant petition stands closed in view of the order dated 31/2021 and the subsequent joining by the petitioner to the said post on the basis of the order dated 31/2015. The parawise comments as well as the order dated 31/2021 as brought on record by the learned counsel appearing on behalf of the Elementary Education Department is kept on record
Lordship, can I
and
get a
marked
copy of
with the
this,
letter
Lordship?
X.
Can I get a copy of this order? Lordship, that's one thing, Lordship. The 6 months may not be included. Recently, 6 months may not be included, Lordship.
Why? 6 months? No.
Recently, I could not contact the client, but approximately may not be 6 months, Lordship. That may not be
6, 8, 9.
Lordship. Recently, that month, Lordship.
While contacting her last time will
Last time. Oblige, your Lord.
And now for orders.
Lord, here, this petitioner is under suspense for 4/4/2022. So steps has been taken.
why the matter has been listed today?
My Lord, I think, my Lord, the team service is required.
So what? All the registry fellow. Why the matter has been listed today when the matter has not been fixed on Tuesday? I'll inquire with it.
Lozima, my Lord. Lozima.
Lozima, whatever may be, how can this matter be listed today when there is no date fixed? And why it has been shown? There is by order. Who has given you the order?
My Lord,
Let it go to that court.
we approach registry, my Lord. I have mentioned, my Lord.
It is by order. Wait. 15/2022. 33/2023. Who has given? Which court must they open it?
My Lord, registry says that you mention it, then it will automatically go to.
Puneli. Huh? Which court? Find it out. Let it go to that court. Whoever gives that permission. Oh, go to court number 3. Get your order there.
My Lord.
Not here. You mentioned it in court number 3.
Yes, well, registry
Then-
said that you mention it, then it will go. But otherwise, he'll return, my Lord. That is the urgency. That is my.
Urgency is there. Go there. Court number 3. If you don't mention the matter before this court,
My Lord.
you know this is a matter pertaining to suspension.
Yes.
And if it is a matter pertaining to suspension, it is written in bold letter out there
I understood.
in the roster. The suspension is within the domain of
My
this
Lord,
court.
my Lord.
Then why did you mention it in before
I
some
am
other
sorry, my
court?
Lord. As seniority, I have mentioned. I am wrong.
Then?
I will mention here.
Yes, education department. Who education? Yes, Mr. Sharma, you also take up matters pertaining to secondary education. also.
Secondary.
Yeah.
Headmaster.
Hmm?
Lordship 6991.
6991. This matter should have come up for admission, huh?
Lordship.
You are suspended.
Yes.
Since when?
March 4 for 2022. And 3 months they have not started in DP. Then we have filed an repetition. It was disposed of directing it within such and such days. Then they have not done. Again, we came and there's some time. The 30 days more time is required. They have done nothing, my lord. Now he is hanging. He will be going to retire, my lord. So something concrete should be come. My lord. If they are
Lordship will fix some other day, Lordship, I will have the instruction, Lordship. As the secondary council is also. Lordship will fix next week.
Let the matter be listed for admission on 12th.
Of like.
obliged, my lord.
Mr. P.N. Sharma, the learned counsel for the secondary education department shall obtain the instructions as to whether the memorandum of charge or the charge sheet has been served upon the petitioner, and as to whether there has been any departmental proceedings initiated against the petitioner as of now.
Lord.
Petitioner?
And a 5.
Item 5, Lordship, in this case, today we will file affidavit. Already we have handed over copy to our clerk, Lordship, to file the affidavit. And Lordship, I have also received the urgent service book also received, Lordship.
The wrong calculation of after retirement.
Yes, the matter pertains to that thing, no?
It is all covered by your lordship judgment and judgment passed by.
Additional means working
the-
beyond the
Beyond the Lordship,
After the retirement, they found out that my lord, the calculation of.
Lordship,
date of
everything
birth
will be
is wrong.
reflected from the Lordship service book. All things are entered by my petitioner, Lordship. Even date of birth also entered by the petitioner, Lordship.
date
In
of
our
birth-
affidavit,
service book was with whom?
Lordship service book was only with the authority, Lordship.
Why haven't you not taken action?
Lordship.
Tell me the
Lordship,
name
we'll
of the
find-
authority. We'll ask them authority.
find not
No,
only
no,
that,
Mr. Gogoi,
Lordship.
tell me the name of the authority. We'll ask that the department to deduct it from his salary.
Lordship,
That is the
even
best thing.
Lordship, for a moment, assume we are the wrong Lordship. The authority are wrong Lordship.
Yes.
The petitioner in every document, our date of birth is Lordship, written as the date of birth in as like the Lordship, the service book Lordship.
Oh,
Service book Lordship.
that is good.
Petitioner's Lordship,
The petitioner is fair.
no Lordship. How petitioner can be fair? Voter ID,
Obviously,
PAN
he's fair.
card,
He
everything,
has
Lordship.
all along been bringing it to your attention that look here, my date of birth is this. But
Lordship.
then also you are taking his service.
Lordship, we will satisfy my lord. As per my lord judgment, we will satisfy. Our affidavit filed today. Lordship may fix the matter any other day. I will satisfy by my lord judgment.
Why? You satisfied today itself.
Lordship, affidavit not in the record, Lordship.
So you have a copy of it.
Lordship, we have already sent to the.
You don't have a copy of the affidavit?
No,
Let it be
two
at 2
copies.
PM, my lord.
What?
Let it be at
Lordship.
2 PM.
Huh?
Let it be at 2 PM.
Misleading
They
by
will
the
show-
petitioner, Lordship. He has higher Lordship, voter ID card, PAN card, everywhere he has
Yes, I
written the
checked
date
in
of birth
my
as
Bavanga.
Lordship. This one,
Understood.
Lordship. And
So under such circumstances, why haven't you taken any action?
Lordship, it is a bona
No,
fide.
why you will recover it from the petition? That
Lordship,
is the only question.
Lordship. it
When
is-
everything has been brought to your notice, why
Lordship,
will you
everything
recover
was
it?
brought to the notice when the matter was referred back to the AG, Lordship. For
There
accountants
the
and
problem happens.
AG, that it
The
is.
AG always
Lordship,
creates the problem to
college
the effect.
authority bona fidely take the petitioner's Lordship, everything, Lordship.
Who?
College authority, Lordship.
So they have all along represented that yes, my date of birth is this.
Not all along, my lord. What happened?
All was put it by
Are you
petitioner's
saying,
own
are you,
handwriting,
Mr.
Lordship.
Gogoi,
All
are
was
you
put it
saying
by
by
petitioner's
on
own handwriting.
affidavit,
Lordship.
are you saying on affidavit that the petitioner played any fraud upon you?
Lordship, we have stated in our affidavit that Lordship, the date of birth, Lordship, is inserted by the petitioner herself, Lordship.
Very well, then
Lord. Lordship will satisfy, Lordship. We will satisfy whether petitioner misleading or not, Lord.
then satisfy.
Lordship. Let affidavit maybe come in the record, Lordship.
Okay,
Any day,
we'll
Lordship.
bring the affidavit. You have a copy? Have you
No,
served?
Lordship, we have
a
not served, just we have delivered.
They have not served.
copy?
Just delivered to
Oh.
our clerk to file
They
it,
are
Lordship.
burdening themselves with interest, my lord. This is what I am saying.
No, Lordship, that is
They
not
are
the fact.
burdening themselves
That
with
is
interest.
not the fact, Lordship. If he is the true person, Lordship, then the
No,
third.
has he taken the money from you?
No, they have not taken. They are saying that you will have to recover. What has happened, my lord? In the year 1988, when she took, he got appointment, in the service book, her handwriting is there that my date of birth is 62. But this is to be, my lord, that your lordship knows SR 8, that it has to be, it is authenticated by the principal of the college. Then it remained like that. And according to the principal of the petitioner, as per her, she miscalculated it. It remained like that in her PAN card, in her passport, in other documents. It is
It is
62.
not a layman, Lordship.
No, let me
Not a
just
layman,
finish it.
Lordship.
So this is how, my lord, and
Not a layman,
the
Lordship.
matter sent to the, my lord, AG on the brink of her retirement, and the AG shows it should be 61. This is the position of the case. So therefore, my lord, the government notification is there. Everything should start before 24 hours, 24 months before the date of return. If they would have sent the paper before, as per the government circular, the AG could have corrected it. Man, this is a miscalculation of date of birth on the basis of the, my lord, that admit card given by the petition. So according to the petitioner, it is 62. According to the authority, also it is 62. So therefore, the correctness has been shown by the AG after her retirement. If they would have acted as per the government circular, government's intention is to pay, my lord, pension on the date of her retirement. Anybody is retired, but they do not act anything. They are supposed to go through the service book and check the date of birth again and again.
No,
every
you
year.
not got the pension.
No, the pension, they have, Mr. Gogoi has given me a, my
Lordship,
lord,
provisional pension already allowed,
provisional pension letter. The pension letter, she did not get anything.
Has she got her
No,
pension on?
No, only letter has been given by Mr. Gogoi.
No, are you not aware the government is contemplating that the person who is going to retire 1 month, 1 year before? No?
Lordship.
24 hours.
You are going
It is
to
the
24 months
duty of
before.
the incumbent
no.
also, Lordship. As per
Mr.
my
Gogoi,
lord
are you-
judgment,
I think
as
they,
per my lord judgment, it
Is
is
the
the
government not going, not contemplating that a person 1 year before
Lordship.
is going to
24
stop
months
the,
before.
Lordship, it is the duty of the incumbent, the petitioners also, to inform the authorities that my date of
What
birth is
is
so and so, Lordship.
All the government
It is
circular.
covered by my lord judgment. We will place everything, Lordship. And petitioner himself stated that CS
Mr. Gogoi, don't worry about my judgment also.
Lordship.
I am not bound by my judgment also.
I am
If
not
I
saying
feel-
that Lordship is
Well, let
bound
him
by
come
my
and
lord.
Don't
prove
worry
here, my
about
lord.
But
Let me
Lordship
finish,
has
my lord.
already
I'll
decided
take
that
only 5
particular
minutes.
point.
I have decided many other points also.
Lordship has decided the burden, Lordship. Burden part, Lordship already decided. And we will also, Lordship,
You are referring to that judgment where 59,000 was returned. Isn't that the case? Where I said that he is not entitled to the
Yes,
59,000.
Lordship. Regarding the duty of the petitioners to inform the
But in
authorities.
that judgment, did I consider Jagadish Pandey?
The Lordship has decided that.
No, I have not considered. Neither I have considered Rafiq Masih. Neither I have considered Jagdev Dey. Neither I have considered Thomas Daniel.
Even Lordship, Jagadish.
Don't worry, Mr. Gogoi.
Pandey
don't worry.
Jagadish also, Lordship, did not consider our statutory rules, Lordship.
Hmm?
Pandey Jagadish, Lordship, is not consider our statutory provisions and rules, Lordship. There is a pension rules is there, statutory provision is there, Lordship. We are bound by the statutory provision, Lordship. And a petitioner's duties also they are to follow the statutory provision what is prescribed, Lordship. Petitioner not a layman, Lordship. He is not an uneducated person. He is a master degree holder, a doctorate also, Lordship.
But does Rule 95 say that you can recover?
Lordship,
Does Rule 95 say that you can recover?
Lordship.
No, it
Lordship,
doesn't.
OM says that
No.
office memo.
Rule 95 does not say that you can recover.
OM says that. Office memorandum is there, Lordship.
Office memorandum is there, but Rule
Office
95 does
memorandum is,
not
Lordship,
say. The
incorporated in
office memorandum cannot override the rule.
Lordship. Office memorandum is all.
Are you going to give the effect
Recover
of
is
an
there
office?
in the rule itself. Recover is there from DCRGs, Lordship. I will place, Lordship.
Where? Oh, then very well. We
Lordship.
take up the matter for final dispute.
Lordship. Procedure 9 has
Rule 95 says he can't claim benefit. But Rule 95 does not say that he cannot, you can recover. Isn't it?
Lordship,
There is a judgment of Mr. Jayant Sharma on the basis of the notification issued under Rule 95, 12% interest has been given.
Here the question of interest doesn't arise, I suppose.
May I give the judgment of Mr. Jayant Sharma?
my lord judgment, paragraph 17, Lordship.
What does it say?
Paragraph, Lordship,
No. I understand. I've seen that.
paragraph 17, Lordship has already taken the view that we can recover.
Huh?
We can recover as per 90. Conflict with the even Lordship.
So your entire case is on the basis of this. Are you hinging your case on the basis of this judgment? Don't worry with this. I'll take care of it.
Lordship, I'm not saying that, Lordship. Otherwise, also, Lordship, if the office memorandum is not conflict with the rules, then office memorandum will prevail, Lordship. That judgment also there Supreme Court, Lordship.
Very well.
Lordship may fix the matter tomorrow also. I can place a BT.
Why not today? Today we have time.
Today, Lordship, I have not bring that those judgment, Lordship.
Huh?
I am not bring that those judgment, Lordship. Where the validity of the office memorandum we can establish, Lordship.
Mr. Gogoi, let us assume,
Lordship.
forget about the judgment.
Lordship.
Let us assume what you say is to be
Lordship.
correct.
Lordship.
That an office memorandum can prevail
Lordship.
unless it is repugnant to the rule.
Lordship.
There's no quarrel.
Lordship.
That by way of an executive instruction, you
Lordship.
can supplant something
Lordship.
which is not there in the law is clear.
Lordship.
For that, you don't need the blame. Then,
Lordship, we can recover.
eh,
We can recover from this year.
you can recover from the DCRG how?
Lordship. The procedure is there in office memorandum. I will test the office memorandum. That I asked my friend to start it. It is there in the pension member. My lord may fix the matter any other day. I will place everything.
At 2 p.m. it can be taken, my lord. You can file the affidavit. Let it be at 2 p.m. You can take
Have
time,
it
my lord.
when? After vacation.
My lord,
Before vacation also,
will not
Lordship,
fix
I
it
have
after-
Huh?
Your lordship will not fix it after vacation. At a date, my lord. He
No,
says tomorrow.
otherwise this court has no time, Mr.
2 p.m.
Mr. Das kindly appreciate one thing. This court has no time prior to that because next week, you know, it is a busy week.
I'm saying, my lord, let it be
And-
at 2 p.m.
And
He-
2 p.m. is also, how is it possible? There are other matters will take the fall.
Otherwise, this
It
case
is not a
Gogoi has
case
been
that, Lordship, we are
successful.
recovering that amount, Lordship. We have also passed the order for provisional pension, Lordship.
I will also pray for
But
in-
in
interest,
provisional
my lord.
pension, it is not a case that we are recovering the amount. We are doing what as per my lord direction, Lordship. If Lordship directed us to not to recover it, we will not recover. And if Lordship found that, Lordship, we are entitled to recover, then we will recover. Now it is in our pocket, Lordship.
In
Yes.
whose pocket?
In a petitioner's pocket.
You have already paid the DCRG.
DCRG, she cannot now, Lordship.
So on that interest will calculate.
Lordship may calculate everything if she is entitled, Lordship.
Yes. I'll put it on record.
Lordship.
Heard Mr. P.T. Das, the learned senior counsel, assisted by Mr. R. Tekar.
এটা মানলে না?
Mr. A. Gogoi appears on behalf of the Higher Education Department. And Mr. R.K. Talukde appears on behalf of the Accountant General AE Department. The learned counsel appearing on behalf of the Higher Education Department submits that they are in the process of filing their affidavit today. After serving a copy of the same to the taking into account the same. This court fixes this matter on 21st of April 2023.
Lordship, after 23rd, Lordship, I am out of the station up to 23rd. Lordship.
On 27th of April.
Lordship, Lordship. My Lord may also indicate that we have received the service book. As per Lordship's direction, we have received it.
The service book, Mr. A. Gogoi had submitted that the service book of the petitioner has been received from the department. He shall produce the same on the next.
Oblige, Lord.
Hey, you take this.
Lordship.
Don't worry.
Oblige, Lord.
My lord, can I take back all those judgments?
Yes.
Oblige.
Item number 6, part out for hearing.
May it please your lordship. The lordship has in detail had a hearing. my lord,
Item number 3 to the 4 to 2. Final which to very direct to remove it. Yes.
Well, a learned friend was directed. Well, the issue was since Indra Sawani said that mandamus can be issued.
The APSC matter.
Yes, that relaxation.
But how can I take it? I think
No, no,
Mr. TJ Mohanto is in bereavement.
Yes.
Yes.
We'll have it on some other day.
Yes,
Have it after vacation.
only lordship will give a date because
Yeah.
the urgency part is there.
It's a part-on matter.
Yeah,
isn't
yes.
it? So we'll have it on, we can have it on 21st.
Lordship, some
Yes,
difficulties. there
21st will be.
From our chamber, 21st is some difficulties. Before or after your lordship 21st?
April. Well, the vacation ends on 19, 21st, 23rd lordship. Then.
Oh, yes. 25th?
25th, matter before the division bench, the whole day, the reservation matter. Can it be on 24th?
24th is holiday.
27 Thursday.
27th. Taking into account that Mr. TJ Mohanto, the learned counsel, senior counsel, who is to represent on behalf of the APSC, is in bereavement. The matter stands adjourned to 27th of April 2000.
Item number 9,
As per order dated 25, 2022, the matter was directed to be listed in the part 2 list, sorry. And it has come today in the orders column.
Yes, what is your case?
Lordship, in this case, a petitioner was appointed in the year 1999. Thereafter, since after his joining Lordship, his salary was not paid. Then they approached this honorable court. Honorable court directed the authority to examine the case of the petitioner. Order of the honorable court, Lordship, at part here, Lordship kindly come to case.
To include the name of the petitioner in the list prepared for
15, Lordship.
regularization and regularize the services of the LPC. Few areas salary from the previous two. So first, you have to be regularized. Have you been regularized in the meantime?
No, Lord.
So this court has to pass an order directing your regularization.
No, not that.
Isn't it your pair at page number 12?
Lordship, that is mistaken, Lordship. Actually, this court directed to examine the claim of the petitioner. That is, Lordship, kindly have a look at page 24.
Whatever may be, Mr. Counsel, are you foregoing your right to
No.
regularization? You
No,
want regularization or no?
no, Lordship.
Or can this court grant you the regularization, the direction for regularization? Unless you come up with a case that similarly situated persons have been regularized where you have not been done and there is a pick and choose method being. Not on the ground that you have length of service. No, not on that. But only because this court is bound by the judgment of the Supreme Court in Umadevi, by which 226 jurisdiction is limited, by which I can't issue a writ for the purpose of regularization. Yes, you can make out, if you can make out a case to the effect that, look here, this is a case by which I am, along with me, there are other people who were there, they have been regularized, but they have picked and choose me and not granted me the benefit of regularization. Then it's a different thing. Is it your case? It is not.
Lordship, actually, it is. But mainly, Lordship, area salary, Lordship.
So you forget about the regularization. Okay, now come to the area. You are entitled to the area salary from 1999 on the ground that you have been working out there and they have taken your service. That's it.
Lordship, kindly come to.
Now tell me whether you were appointed against a sanctioned post.
That is, as per advertisement, they were appointed against the
No,
same.
because otherwise, if it is not a sanctioned post, who is going to pay you the money? There's a problem out there. You understand that?
Lord.
Tomorrow in your house out there, if somebody asks you, yeah, give me some money out there, how are you going to pay unless you have a budget for that? You'll have to have a budget that, yes, I have a budget for this particular sanctioned post. This is the salary which I'm going to pay. How will they pay unless there is a sanctioned post?
But otherwise, Lordship, they have appointed and Lordship, my service was also accepted, Lordship.
Very well. Where is it? Let's
Lordship,
see your appointment letter.
Lordship.
Subject to discharge without notice, and you'll be initially
Page
paid a
15, Lord.
stipend of if he cannot succeed the final examination, you would be paid to year. This is the type of a stipendary teacher. So you have been appointed in terms with section rule 3 of the 77 rules. Then
Lordship, then your Lordship.
then
kindly
what
come.
happened? You were found as excess.
Lordship.
There's the problem.
Lordship, my service book, that is at Lordship, page 19 onward. And
Okay, now you have been found
earlier
as
order,
excess.
Lordship, kindly
Now,
have a look at
after-
page 24.
No, while finding you in excess, the Manohan committee gave 3. One as a person who have been, number 2 comes within the ambit that which are legal. Number 3 is legal, number 2 is illegal, and number 2 is irregular, number 1 is illegal. You come under 1 or 2?
One, Lordship,
You come under 1,
Lordship.
illegal.
No, legal, but Lordship, my case was not till date.
No, if it is a legal, then there is a question of non-pay. You don't come within the ambit of excess. If it is legal, you don't come within the ambit of excess. Therefore, you are entitled to. And then, by virtue of your appointment made in the year 1999, read with the service code, service rules of 1981, you are entitled to everything.
Lord.
So you don't require regularization. The fact that you require regularization also shows that there is something wrong. Isn't it? Tell me.
So Lordship,
Lots, we have filed our affidavit. 2
Lordship,
affidavits, Lordship, even additional affidavit.
What is your stand in the affidavit? Illegal, irregular, or legal?
Illegal means Lordship, Lordship may kindly take up my affidavit by the respondent number 2.
there stands Lordship,
Paragraph 5. The Devon Beck stated that the petitioner was shown to have been appointed as a stipendiary teacher by the auditor so and so in the so and so school, but his service was attached to 278 number so and so school, but he has not stated anything about his mode of selection and appointment in the appointment order. There is no such reference under which advertisement and selection process he was appointed. So therefore, he was appointed as a stipendiary teacher. He has not annexed any document showing his participation in any selection process, and therefore the appointment of the petitioner cannot be treated as valid, illegal appointment. Even in our additional affidavit, subsequently, the appointment of the
What is the name of the petitioner?
Lordship
Abdul
Abdul
Karim.
Karim Latkar.
The counsel, you have no case. Who is the response number 5? Nuruddin Mazumdar.
Lord-
Who is he?
He is the headmaster. Lordship. He
You have made him by name.
Lordship. That time he was retired, and that's why I put him like it.
Oh, how is this? Did this matter come up before this court? It seems that I have read this file somewhere. Or is it so much similar to all files nowadays? Yes, Mr. Counsel, no case. Dismiss.
Lordship, his service was excellent, Lordship, and after order passed by this honorable court, no step was taken by the authority, Lordship, to whether his appointment was legal or he was entitled for Lordship salary or not. But only his service was.
The affidavit of the respondent number 6 categorically shows that you have not worked in that particular school from 1/3/1999.
Lordship, but
I hope you have seen the affidavit.
Lordship. But the headmaster of that school, Lordship, issued certificate.
They have given, now they will come up with another thing that this is fraudulently manufactured. But how can this court adjudicate those aspects of the matter? You are asking regularization is out of question.
Lordship,
Area salary, you can't get it unless you prove it to that effect, but this can't be proved out here. They are saying that you have not been appointed at all. Your only basis is a challan, treasury challan, which you have enclosed to the affidavit in reply, pursuant to the advertisement of 1996, isn't it? Have you at all received any penny, a single penny since your appointment?
I know it.
Obviously, no, because you are asking for your area salary from 99. That is why you have not.
I leave it to your Lordship pass.
Okay. Or you want these matters to come up in the part 2?
No,
Okay, I admit that. Your name? L.R. Muzumdar. The learned counsel appearing on behalf of the petitioner, Mr. P.N. Sharma, appears on behalf of the Elementary Education Department. None appears for the respondent number 5 and 6 of course. The instant writ petition has been filed by the petitioner, seeking a direction that his services may be regularized as an LP school teacher, considering his long period of experience, and further seeking his due area salary for the period from January 1999 till date, along with compensation. From a perusal of the writ petition, it transpires that the petitioner claimed to have been appointed as a stipendiary teacher in Nityanagar LP School. Vice Ishaq Ali Loskor, head teacher, retired. It is the case of the petitioner, though the petitioner was initially appointed to the school, initially appointed to that particular school, but his services were attached to 287 number Tundurkondi LP School with a monthly stipend of rupees 900 per month, and thereafter joined in the service on 13/1/1999. Admittedly, the petitioner was never sent for any training, as is required under Rule 4 of the Assam Services Provincialization, Assam Elementary. What is that name?
Elementary.
Assam Elementary. We'll take on the name. Take Rule 4 of the service code 81. Assam Elementary Education bracket Provincialization Services and Conduct Rules 1981. It further appears that the petitioner had approached this court earlier by filing a writ petition for release of his pay and allowances. Had approached earlier by filing a writ petition along with 6 others for a direction for release of his pay and allowances while serving as a stipendiary teacher in different LP schools in the district of Hailakandi. The said writ petition was registered and numbered as WPC number 1620/2003. This court, by an order dated 7/3/2003, had disposed of the said writ petition with a direction to the respondent to examine the claim of the writ petitioners, and if they are found to be legally entitled to the current as well as the arrear pay and allowances as claimed, the same be released within a period of 3 months from the date when the copy of the order along with the copy of the writ petition is furnished to the respondent court. It further appears that even after the said order being passed, the petitioner did not receive any salaries. It is also relevant at this stage to take note of that sometime in the year 1996, what is that year?
no, 1999.
96, nah? Sometime in the year 1996, the government of Assam was placed in a situation wherein it was found that there were a lot of excess teachers than the vacant sanction post. In order to streamline and to find out the discrepancies in the appointments, a committee under one Sri Manoharan IAS was appointed, which is commonly known as the Manoharan Committee. The said committee took steps and classified the teachers into 3 groups. One category pertained to those persons who were legally appointed. The second category pertained to those who have been irregularly appointed. And the third category pertained to those whose appointment were illegal. It is also apparent from the submission, as could be called out from the submission of Mr. P. N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department, that the government of Assam had taken a decision to regularize those teachers who were irregular, whose appointments were irregular. And as such, sometime in the month of August 2008, 2005 onwards, these teachers whose appointment were irregular were regularized and brought into the fold of the government of Assam, of the services of the government of Assam. The learned counsel further submitted that the petitioner case does not fall within the ambit of those irregular or legally appointed teachers. Be that as it may, the case of the petitioner herein, as could be further seen from the writ petition, is that the petitioner seeks for the relief of regularization of her services, as well as for payment of the area's salary since the date of his appointment. As regards the first prayer, the Constitution Bench of the Supreme Court in the case of So versus Uma Devi, reported in 2004, 660, page 1, had categorically observed that this court, in exercise under Article 2 to 6 of the Constitution, should not direct regularization unless it is within the permissible constitutional mandate, taking into account the said law as declared by the Constitution Bench of the Supreme Court. The first prayer made in the writ petition cannot be granted. Next. The next relief which have been sought for is as regards the area salary of the petitioner from the month of January 1999, that is from the point the petitioner had joined till the date of filing of the writ petition. Taking into account that the petitioner was not appointed, taking into account that the petitioner has failed to show that he had been appointed to a valid sanctioned post of the government, valid sanctioned post in the provincialized school And further also taking into account the affidavits filed by both respondent number 5 and 6, wherein there is a categorical denial that the petitioner had never worked in the school in question since the month of January 1999. This court is of the unhesitant opinion that the relief of arrears salary as sought for in the writ petition cannot be granted to the petition. Consequently, the petition stands.
Obliged.
Then
Yes, Mr. Kaur. There is one matter, na?
Yes.
That matter.
Only one point has to be clarified.
Huh?
Only one point has to be clarified.
Yes, I remember. That's a part of matter, na?
Yes.
Mr. Saiva, let me complete.
My lord, this will be, they want to adjourn it.
That's
Hello,
the
the
senior
senior-
Mr. R. Sharma has just informed me that he's not well. So I'm praying for an adjournment in this matter, Lord.
Which one?
Item 10.
Item number 10. No, he's-
I am for the respondent 2 and 3, my lord. I'm ready.
Your name?
I'm P. Fukan. P. Fukan.
It's P. Pukon, the learned counsel. Last time also you have taken adjournment. What is this?
Lordship, not us. They had certain.
What is this matter about?
Lordship, the retired OHGC.
My lord, they are
officials
asking for
seeking
pension, my lord.
implementation.
There is no pension scheme and they are asking for pension. That will.
Seems you are not interested. You're not interested. This is a matter of 2015. Does it look nice? You should argue the matter. I don't grant adjournment on senior counsel. You know that? Are you aware or not? Then you should argue the matter. Does it look nice for a 2015 pension matter to be surviving?
Just on Tuesday, Lordship.
Mr. Madam, the court doesn't function at your convenience. Today I have time. There's no matter left. Then I will do one thing. I'll put it not before me. Then it looks better. Because if I have it with me, and it doesn't look like that 2015 pension matter is being adjourned. You are entitled, may not be entitled. That's a different aspect of the matter.
Let it be on next Tuesday, my lord.
No, it can't be at your convenience also.
No, I'm.
And there is an interlocutory application for an order that a writ petition be heard at an early date. And you have, both of you have been, and you have been seeking adjournment from time to time.
Lordship, this is the first time you're seeking, and it's just.
Whatever
first
may
time
be.
He has informed me, Lordship.
If it is urgent on one hand and you are seeking an adjournment on senior counsel, does it look nice? We are prepared with the matter.
Not in the entirety, Your Lord.
Huh?
Not in the entirety. I just know some that they are.
You know the
expecting-
facts?
Yes, Your Lord.
Fantastic. We'll take it up. I give you time till 2. Look into it. $2015.
11.
This is the matter?
Yes, my lord, the company secretary of AIDC.
Oh, yes, yes.
My lord, your
yes.
lordship has
I
the-
asked you to, Mr. Goswami, or you to find out one thing.
Lordship,
Without-
whether it is payment or increment, which can be considered for promotion in the stagnation when an employee is under stagnation. In this case, your lordship has rightly pointed out in the last occasion that under the ROP rules of ASSAM of 2010, that this pay scale, which is there, is there in the ROP 2010. Is 2,000 rupees, the 7,600, 7,400 to 7,600, that scale, which they have given. That is there in that.
Mr. Moore, have you looked into the MACP scheme? MACP scheme of the government of Assam?
Here, I think.
2017?
But here that is.
Yesterday I was taking up one matter. The increment would be on payment or grade pay?
But this they have subsequently, when after my entitlement and all, they say that this 200 increment will be only the which is available to me. But these are all, that has to be all retrospective. Prospectively, that has to be all prospectively, not retrospectively. So so far our case is concerned, my lord, it will be payment, because your lordship has asked me also to look for precedential value. In all from this under this slash scheme, that is the which was prevalent at that time, all the 102 employees who have been given benefit under this scheme has been given the benefit of payment, not payment.
Is it there?
We have said the discrimination. We have given some example to show.
No. Every year, whenever a person is entitled to,
Yes.
is it on the payment or the grade pay, which I have asked? You are saying that it is on the
in
payment.
AIDC, it is payment.
Pay-
Because AIDC,
have you, where is it? Let us see.
yes. First, your lordship will see the scheme.
There in the code.
Page 30 of the report.
Yes, page 31. No?
Yes, ma'am. और ये सर्कुलर में ये तो बोल दिया था ना।
As the purpose skill is, where skill that may be added to the there is some office memorandum which was brought out there now on the left page on because the MACP scheme. Where is that?
Yeah, page.
Oh, yeah. Got it. It's your area progression scheme.
Yes. But the initial scheme I will be entitled is at page 30. That your lordship will find in the definition itself. The personal scale of pay at page 30.
Page 31.
Read petition.
Page 31.
30.
30 is what? What is this?
This is the scheme, madam.
That is the scheme. You are
Yes.
referring to page 31.
Now, page 30. First, your lordship will see definition. Personal scale of pay. Personal scale of pay means the approved scale of pay granted to employee under the scheme as personal to him in consideration of long years of service in the same post or grade. This is the scheme. Then the MOU your lordship will find at page 44 of the affidavit in opposition of AIDC.
Running page.
That's the problem because this 2015 Mala at that time there was no running page, so I missed it.
You have so many juniors. Why don't
Yes,
you ask
madam.
them to correct?
Yes, madam.
You have
We'll keep it in mind, madam.
yes.
Page 44 of the affidavit in opposition filed by R4 and 5.
Yes.
Now your lordship will find Government of Assam Finance notification dated 24 August 20 has allowed the AIDC to adopt the provision regarding revisions of pay scales and allowances as provided for the state government employees as per Assam ROP rules, rate with notification number so-and-so with his own resources, and to implement the same. This memorandum of understanding is signed on this 12th day of September 2012 between the Government of Assam and Assam Industrial Development Corporation Limited. Then your lordship will see 2 and 3. The Assam Industrial Development Corporation Limited shall not create any new post without prior approval of the Finance Department through the Industries and Commerce Department, Administrative and Government of Assam. Then any change or revisions in pay scales, allowance, parks, or any other service condition of the Assam Industrial Development Corporation Limited, employees having financial implication and which is not part as the provisions of Assam Services ROP Rule 2010 shall not be made without prior approval of the Finance Department. So, my lord, AIDC has its own service rules 1982 also. There also that scale, my lord, which your lordship has seen in the last paper which they have given. There is no this scale of 7,600. For that, no finance approval has been taken by the AIDC. Finance Department communication I have annexed, my lord, they have not bothered to reply to it. And what the AIDC has done, they have taken, which of course they have taken. They in 2013, they say the slash is more beneficial than this assured career progression scheme. So they have taken some portion from slash, some portion from ACP. And if they say that in 2010, when ROP came, we have been given to all the area, they adopted in 2012, we have been given all the area pay and all. And under that ROP 2010, along with the assured career progression scheme, they can't pay bonus and gratuity which they are paying. And that's why, my lord, in AIDC, whenever it is a case of promotion, it is always payment. Even now, the last time of course, it was a feeble effort was tried to be made to show that we can do it up to only the deputy general manager level. So far, I am concerned, because in 2012, 2013 January, when I was entitled, I was holding the post of DGM, and some employees, some managers, well, if I get the scale of GM, then I will become the almost the senior most person in AIDC. So that's why they have created this 200 rupees increment and denied me all these years. All those people who have taken those initiatives, now they have all retired. They do not want me to have the senior most scale of the AIDC at that time. So that's why this is all.
You are alleging malafide? Are you alleging malafide?
No, I am alleging discrimination. Discrimination is.
Then your submission that those people are not allowing you.
This is the background. This is the background.
That would be a case of malafide.
No,
if you are not doing it, then why should I hear all these things?
That's why, my lord, I have not even. That's why I have not even challenged the persons who have been given higher scale of pay in the GM scale and all.
But Mr. Court, don't you think that the case is otherwise on a very simple aspect? That look here, you are entitled to a financial upgradation.
Yes.
If you are not being given a promotion
For
after
last 20
working for a
years.
particular year.
20 years, more than 20.
And the only aspect is whether the financial upgradation, there might be two aspects. One is whether the financial upgradation would pertain to the pay band or the grade pay.
Absolutely.
The second aspect would be as to whether the financial upgradation, whether 7,600, which is the grade pay,
Yes.
if the first is held to be grade pay,
Yes.
not pay band,
Yes.
then in that regard, whether the grade pay has to be in tune with the ROP. If it is not, then you can't have any.
And ROP also, my lord, this 200, they have adopted it after my entitlement and all. This 200, this scheme and all, because it has to be adopted. Ultimately, you can't say that ROP will come into being. The AIDC has to adopt the ROP. This they have adopted it subsequently, and then we got the areas and all of 2010 and all. Our case is that this, which they are talking about the increment and all, is all prospective after my entitlement. Under this scheme of my lord at page 30, as many as 102 employees have been given. The 102 employees have been given the benefit, and it is all on pay band and not on increment. So your lordship will hear him also. what he has to say, because this was on the last occasion where we got stuck up, my lord. Let us hear, he must have some instruction, then we'll again respond. My lord.
Lordship, so for the entitlement, whether the petitioner have the entitlement for uh, uh, on the basis of the scheme, Lordship. Read the- Now in the page 31 in the writ petition, Lordship. Scheme A, capital A, an employee who completed 10 years continuous satisfactory service in the same grade oblique post and is otherwise suitable for promotion to the next higher post. It means he must be suitable for promotion of the next higher post. Lord. But the petitioner is not at all suitable for the next higher post. Lord.
Why?
Yes, because Lordship, now he is in the position of DGM, Lordship, equivalent to the DGM. Next is the GM, and she has not qualification for the post of GM, Lordship.
Why, no, why you're reading that? Shouldn't we read further?
Your lordship will read the 5 lines.
Promotion
yes.
rule,
But
remains stagnant
Yeah.
due to non-availability of vacancy.
yes,
Then
Either
next
for
one.
Yes,
filling
yes.
up the post by the other interim incumbent or no further sanction post.
yes.
Then my lord, your lordship will see,
First,
will be
Mr.
eligible for-
Kaur.
Yes, my lord.
Mr. Kaur,
Yes, yes, I got.
I gave you all the
No,
opportunity.
no, my lord. Since
No, don't.
Yes, yes, yes.
I have
withdraw.
already given you all the,
Yes.
you have said that let us put the
Oh, my lord, he
ball
has
in
to come
Mr.
again.
Goswami's
He has to come again. That's why I
No,
posted.
okay,
After that
whatever
line,
it is,
next
let him
higher
argue
gets
that, then we'll hear. You take
Yes,
a
yes,
seat.
yes.
Yes.
Now, Lordship, the meaning here, my Lordship,
Mm.
otherwise suitable for the promotion to the next higher post as
Good look.
required under the promotion rules, but remaining stagnant. It means he must have the suitability for a higher post. In that case, if he is not entitled the higher post, Lordship, then this scheme will come.
But Mr. Goswami, tell me what is the idea behind this ACP, MECP, or this? What is the
To
idea behind?
encouragement of the employees,
Absolutely.
Lordship. That is
So,
now
if,
now
if,
how
if
how
a person on account of there being, yes, a promotion is not, he has the suitability, but he has not been promoted because of for whatever reasons, there's no vacancy out there. There's only one. Just for example, there is a case where at that point of time when I was there, you see the commissioner of transport is one single cadre. Do you have a lot of assistant commissioners and all
yes,
this? So everybody can't become.
No.
So these persons concerned may go out there, but can't, for which they would be given the post of the commission. This is. But
No.
there might be some cases where there is no opportunity for promotion at all. Then also there is a case by which that to morally boost up. Otherwise, this person, just for example, he was getting 10,000 rupees, it will stagnate. For another 20 years, he is getting the same thing.
yes, Lordship.
That is the reason why this particular scheme of
Scheme.
MSCP, SCP, and all these things have been brought in.
Yes.
So
That's
that is
why
why you have to read
yes,
it
Lordship.
into that
That's
effect.
why I'm coming to that point. Lordship. Now
Yeah, I get your point. You
Yes.
say that the petitioner needs
Now-
to be an engineering or something graduate to that effect to become a DGP, the GM or to that effect.
Yes.
And he doesn't have the qualification. And as such, he's not.
now what the petitioner got, that is the matter here in this. Lordship, the petitioner was joined in AIDC on 12/7/1995 as the assistant company secretary. After that, Lordship, he was upgraded on 11/7/1995 after 2 years, Lordship. They upgraded and pay higher scale, Lordship. After that, Lordship, on 21/9/2021, when the AIDC revised the designation of the company secretary department, Lordship, she got the post of grade 2 post, the company secretary grade 2, and thereafter, Lordship, in the year of on 31st/12/2002, she promoted for the post of company secretary grade 1. It means from the date of joining, she promoted consecutively into to higher grade, Lordship. And then after, it means grade 1 company secretary grade 1 is the equivalent to the GM AGM, Lordship, deputy general manager, Lordship, and therefore the further post, it means she has no qualification on that count, Lordship, and therefore, Lordship, the AIDC upgraded the petitioner to the next higher grade, Lordship.
So the
Higher
fact
grade
that,
pay,
no,
Lordship. It
so
is
the fact that
7,600.
no, so the fact that Mr. Kutami, the petitioner is entitled to the financial upgradation is there.
Yes.
Here the petitioner has come in, said, why are you giving me the financial upgradation on the grade pay and not the pay band? That is his issue.
Yes. No, Lordship.
That is two issues. One
yes.
is, could you have artificially created this grade pay only for the purpose of the petitioner? Or could you have given that? That is his issue. The fact that she is entitled to an upgradation is not an issue.
Lordship, kindly see page 37 in the affidavit in opposition, Lordship.
Yes, got it.
Yes. 17.17, Lordship. The ACPS invest placement in the immediate next higher grade pay within the existing pay band of the employee in the hierarchy of the existing pay structure. Copy of this is enclosed here. She was
However, employees in
however,
receipt
employees
of
in
the
the
maximum
grade pay in the pay band,
if eligible under the ACP, would be given the benefit of one increment under the ACP without any change of the pay band or grade. Does the grade pay after the final upgradation under the ACP? What do you say about 18?
the financial obligation would be admissible up to the higher grade pay of rupees 7,400 in the pay band 4. Pay band 4, Lordship, it is from 21 to 29.
Mr. Goswami, you want this code to pick up only 17, not 18?
17, 18 is there.
No,
Lordship.
I understand.
at
You
that-
want only this code to pick up only 17 and not 18?
Now it is there Lordship, this is pay band 4, Lordship. Pay band 4 maximum. Pay band 4 is started from 21 to 29, Lordship. Page number 43, Lordship. This is the part of the part of this, this is the.
So payment 4 does not conceive 7,600.
Yeah, yes. Have 7,600.
As per the scheme, it does not. As per the scheme, it does not.
Page 43, Lordship.
Understood, but what do you say about 18?
18 is there, Lordship, but it was modified, Lordship.
The financial upgradation under HCP would be admissible up to the highest grade pay of rupees 7,400 in the payment 4. Or you mean to say that 18 would mean that this financial upgradation, if a person has to be in payment 4, would be given to those person who has the grade pay of 7,400 up till. There might be 7,600, but till 7,400, a person would be entitled to.
Therefore,
Is page 43 a part of the
yes,
document?
yes. The part of the document also. Because it is stated in paragraph 17, Lordship, that the copy of the existing pay structure is enclosed with the notification.
So it is 7,600 is a part of the existing pay structure.
Yes.
So the question that it was only created for you, him, or her, does not arise.
And Lordship,
And at that point of time, when page 31 of the writ petition was applicable, this was under the 4th pay.
it's 3,
Page 31.
31, yes.
That is under the 4th pay. Or is it on the 5th pay? This is under the 5th pay, na? Yes, 5th pay. Yes. Page 31. One zero five zero one five. Now this scale of 29 finally come to page 43 of the affidavit and read it with page 31 of the writ petition. This scale of 1035, 375 to 1,000, 16,050 was not there earlier.
Yes.
This was when did you bring it? Did you bring it because of the ECP scheme being adopted?
Yes, yes, after MOU.
This scale came in.
Yes.
Earlier, this scale was
No,
not.
no.
No, that day you gave some paper, na? Oh yeah, but this 19, which is given as the pay structure.
Yes.
What is this MS? That is that one. What he's saying, MSALS.
Well, this is what they have done is modified service advancement link scheme, which is well, alien to all this either to the government and all. They have pick up half part of ROP, they have half part of ACP, half part of slash, and just to deny me this as I
Are you challenging their? Are you challenging in any manner their scheme? No.
no, under the scheme I am not sure. Because I am entitled under that scheme.
So in short, Mr. Goswami, your case is that after the MOU, you adopted as per that page 43.
Yes.
And therefore, there was another payback, another slab was inserted.
Yes,
And this slab you have given it.
yes, that is my case. And she got three upgradation or promotion within 30 years of her service, Lordship. And now in the present MSCP's, Lordship, it is stated that, Lordship, if three further entitled benefit that can be granted, none. After three benefit, she will not entitled to get the benefit. It is just it.
That's a 2017.
Yes, Lordship. Second page.
2017, one thing is very relevant is HCP would include factor. You have a copy of it?
Yes, Lord.
Read this P Roman 3.
Roman 3. The financial upgradation will involve grant of one increment in the payment of the employees without changing the GP. In case any employee is drawing the higher amount of the PP, he would not grant an increment.
He would be granted an increment.
Yes, he would
And
be
the
granted an
payment for
increment
the purpose shall be deemed to have been extended to
extended
that
to
extent. So there would not be a change in the payment.
Yes.
But as per slash, there's a change in the payment.
Let's change the payment. But here,
Doesn't slash at page 31
yes,
says about the change in the payback?
Yes.
Not on the rate. Because if you see page 43, the corresponding was flat was at serial number 28
Yes.
for the DGM. And for the GM has been given at payment 1, payment 5.
payment.
So therefore, you see, as per slash, it is different. They are not applying this ACP or all this thing. Now, by virtue of this memorandum, when did the slash come in? And where? And do you have the scheme of
21/9/2001.
Huh?
21/9/2001.
and the memorandum is subsequent date?
Yes, all subsequent.
Okay.
21/9/2013.
Now, was the petitioner entitled to the financial upgradation as on prior to that MOU?
MOU was MOU was on 12/9/2012. 12/9/2012, and she entitled on 13/9/2013.
Not before.
Yeah. After obtaining ROP, Lordship, after adopting ROP, she got.
So what is your scheme now? MLA, MXLA? I come back 5 minutes.
Yeah.
ROP 2017. কোনটো refer কৰিছে তাতে Your lordship is looking into ROP 2017 which portion?
Government, you are giving the ROP of there. No, I'm asking you what is this MLALS?
MSALS.
Yeah. Serial number 19.
Yes. Well, full form is Modified Service Advancement Link Scheme.
Understood. But where is
Lord.
Mr. Quirk,
Yes,
it is not the fact that there was no 7,600 feet. Was it?
Well, let me be again be clear. Let me be more clear. This 7,600 this pay scale, well, this grade pay was there in the ROP 2010. Okay. Then, my lord, came the memorandum of understanding with the government. Memorandum of understanding came in 2012. What was the memorandum of understanding, my lord? Your lordship will see the wordings of that memorandum of understanding again. Page 44.
No. One thing is clear that there is your submission that there was no 7,600.
No, my lord, it is not. It is not there even today till the in the AIDC service routes.
I'm not about the AI. I'm saying about there was no corresponding rate pay of 7,600 in the ROP of 2010 would not be correct.
No, it's not that. But AIDC has to adopt it. My case is that their adoption has been taken place only after my entitlement, because otherwise I'll be entitled under slash. So the adoption has taken place. This 7,600 adoption has taken place after my entitlement. And it's an admitted fact in their communication.
Show me that, what is it?
Yes. First, your lordship will see, I did not show your lordship, but it is this 7,600 is there in the ROP 2010. There is no dispute about it. Now your lordship will see their impugned communication, page 36 of the writ petition matter.
Yes.
We'll read it from the beginning itself. The Board of Directors in its 2061st meeting held on 26/8/2013 decided to continue the existing service link advancement scheme because my lord, the board found that the service link advancement scheme is more beneficial to the employees of AIDC, which was introduced with effect from 21/9/2001 with the approval of the Board of Directors of the corporation in its meeting held on 1/9/2001. With the following partial modification because of signing of MOU by the corporation with Government of Assam and adopting the revision of pay scales and other allowances as per Assam Services ROP rule. Means ROP rules which has to be adopted, which is applicable to the state public enterprises and all. If they want to make any change, then approval of the SPE has to be taken. Now you'll also see the first paragraph. As AIDC has adopted the pay scales and other allowances of the state government as per the Assam Services ROP rules 2010, an employee who will be considered for upgradation under the service link advancement scheme will be entitled for financial upgradation to the next higher grade pay only. This is where we say that it can be applicable retrospectively. After revision of pay scale, as there is no individual pay scale like pre-revised pay scale for each category of post, only pay band with grade pay applicable. The benefit granted to the next higher pay scale should be modified as next higher grade pay in the approved pay band pay structure. As AIDC has not adopted the pre-revised scale, your lordship will say, as AIDC has not adopted the pre-revised scales of pay of rupees 10,375 to 6,050, which has been revised to pay band of so and so of 7,600. Henceforth, the board adopted this pay scale pay band to grant the benefit under the service link advancement scheme to the eligible employees who are in the. So prior to 13/9/2003, AIDC has never adopted this 7,600 grade pay. And you also will see, then you also will see. Communication which was
And your entitlement arose when?
in 1st of January 2013, and this is subsequent. This adoption is subsequent, 13/9/2013. That's the whole case, madam. And prior to this 39,213, as many as 102 employees of AIDC has been given under that old scheme. What the problem with AIDC is they're taking something from ROP 2009, something from slash, something from ACP. You can't. If you say that under ROP, this ACP will be applicable, then you cannot have a slash. But all this adoption came subsequently after my entitlement.
But don't you think that the AIDC would be bound because of the MOU?
Yes. But MOU also, when the MOU was signed, then also, it has to be adopted. It's not that it is not, the IDC by their own admission has said that we have adopted now. 13/9/2013.
Understood, but wouldn't they be bound?
If you are bound, then you are bound by everything. Prior to this adoption, as many as 102 employees have been given. You can't say that only part of the ROP will be applicable and part will not be applicable. You can't have blow hot and cold at the same time. And even in the communication, which my learned friend, I did not want to interrupt him, but your lordship will see that. Page 40, just a minute. The communication, the first 5 lines which he was reading, my lord, just a moment. Communication, just a moment. Page 31.
Huh?
Page 31, the skill.
Yes.
then A, my lord, your lordship will read A. An employee who completes 10 years continuous satisfactory service in the same grade of post and is otherwise suitable for promotion to the next higher post as required under promotion rules, but remains stagnant due to non-availability of vacancy, either for filling up the post by other incumbent or no further sanctioned post, will be eligible. This is important. Will be eligible for being placed in the next higher scale. It's not grade, my lord. In the approved pay structure as his personal scale of pay, my lord. Prior to 2013, that impugned order, this 7,600 is alien. Why I say again, your lordship will see the affidavit in reply filed by the respondent number 4 and 5 on 10/1/2017.
10/1.
2017.
Yeah.
Your lordship got it? Now your lordship will kindly look at page 13, annexure 3. 1-3. This is for information of all concerned that gradation list of all the employees non-technical department of the corporation is prepared in order of interest seniority in their respective grade posts as on 1/3/2016. The gradation list is as follows. General manager, then your lordship will find pay band of 7,400. Here also this 7,600 is not there. And your lordship, if your lordship looks into the service rules of the AIDC, your lordship will find here also till date, the AIDC has not modified its service rule to include 7,600. Take a look at it from this side, please. Here also this 7,600 till date, my lord. As a specific, the 7,600 is not there in the service rules of AIDC, my lord. Because you need to have the event for change of the service rule, you will need the approval of the State Public Enterprises Department of the Government of Assam.
No, this is what document you are relying is the board of directors is 205th meeting held on 1/9/2001.
Yes, madam. No, there was a 255 meeting of the board of directors also. In the 255 meeting, that board, madam, they have annexed one paper. They have not annexed the paper
Change
which is
happened on that particular document which you have enclosed. You have challenged 13/9/2005 or something.
yes, ma'am.
11 or 13.
Yes,
That
ma'am.
document.
13 March 2013. Sorry.
Ah.
No. 13 September 2009.
13. So this is the meeting held on. There is a in that thing there is a mention about 26/8/2013 board meeting of.
Yes. Even in the affidavit in opposition, my lord, they have referred to one board meeting, which is the 255th meeting. In the 255th meeting of the board of directors also, my lord, what they have the AIDC has taken a conscious decision, my lord. I have highlighted in my representation, my lord. My lord, just a moment.
267.
My lord, just a moment.
231st.
My lord, just a moment, my lord, I have just taken it out. Your lordship will ask them to produce. वो तो मीटिंग में था ना कि प्रेजेंटेशन का बात बोला था. Just a moment. At page page 34. Because I'm a part of the, I could have annexed this board resolution, but what they had done, once I annexed the board resolution in one of my affidavit, they issued a show cause against me. That's why I have referred, I have even annexed that show cause also. My lord. At page 34, your lordship will find at around quote, second last paragraph from the bottom. In the 250th meeting of the board of directors of the corporation held on 3rd August 2012, the ACP scheme was placed
Page
before the
34
board.
of what?
My lord. Read petition, my lord. Page 34 of the read. Your lordship will see the second last paragraph from the bottom. In the 255th meeting of the board of directors of the corporation held on 3rd August 2012, the ACP scheme was placed before the board, and the board, after deliberation, noted that service link advancement scheme is more reasonable and acceptable to AIDC Limited, and hence allowed to continue the said scheme in the corporation. I am a company secretary. I know what are the board resolution passed. I could have annexed this, but I did not annex it because then they will issue a show cause notice to me that I have taken out copies.
When was this benefit being given to this 102 employees?
102 employees, madam, prior to this impugn order, madam. 102 prior to this impugn order of
Adoption.
September.
But was it between the memorandum and the adoption?
Well, exact dates to
That is then
yes,
only
madam,
the question of discrimination comes.
even if it's this higher grade scale of pay, is even given today to the juniors, not this 7,600. It's all the promotion which have been given in AIDC even till date. I was there in the last board meeting also. 2 of my juniors have been given. All have been given on the basis of payment. This pay, this great pay is only for me, only to deny me. But that's what I'll show your lordship. I have pointed all the, your lordship will see all the persons who have been made GM and all.
How can there be a grant of a, as of now? The next, just for example, in the case of Directorate of Agriculture, the director scale of pay at that point of time was 12,000 to 40,000 with grade pay of 7,600. The second one is the additional director. His scale was 12,000 to 40,000 with grade pay of 7,400. That is why I'm saying it is not foreign at that point of time was also there. Now, is it your case that during this period, they have given the benefit without taking into account the what we call the memorandum entered into with the government?
No,
Then it is a case of discrimination.
There's 2.
But I don't think that would apply because of the fact that it is only this particular scale which was brought in. Earlier, all other things remain.
I could not take it.
Company secretary, there is only one grade 1.
Yes.
And grade 2 also 1 or 2, maybe whatever.
No, there are only one company secretary. They will not get a second company secretary even if I retire today.
No, there is one company secretary grade 1, one company
Yes,
secretary.
because I'm the only one, because nowadays nobody
No,
joins the
whatever
government.
may be. Now, company secretary grade 1 or the other who your rank is equivalent to the DGM.
Yes.
Is it your case that these DGM were given the scale of the GM after the memorandum and before the 13/9/2000?
My lord, or means even after this, my lord, without taking any government approval and sanction for pay, they have given this payment to other incumbents also.
Other incumbents doesn't come in because you stand in the footing of a DGM.
Yes, because there's no.
So there are other DGMs also. So those other DGMs, there will be 3 or 4 DGMs. No, there are 3 GM, and there will be more DGMs. Now with these DGMs, we're given the payment of the payment of the GM. Is it your case that after the memorandum entered and before 31/13/9/2013, that is your case, that is then only there will be a case of discrimination.
But even otherwise, my lord, what the AIDC has done, they have not adopted ROP 2010 till September 2013.
Understood. But they have entered into
My
a
lord,
MOU.
that specific instruction, my lord, it's only a phone call, my lord. That after the
No,
MOU,
if your case is of discrimination, the
Yes.
discrimination can happen only on that, because the company secretary's post is equivalent to the DGM. So whether any DGM, in the meantime, after the MOU and before 13/9, got any benefit by given the GM post.
yes, my lord. Yes, given, my lord. Yes, my lord.
That is what I.
Yes, madam.
Then only a
I'll just
case
check
of
the-
discrimination.
Yes, madam.
Isn't it, Mr. Gustami?
Yes, yes.
That is the
Yes,
specific.
yes, Lord.
Your lordship will also see the comment by the additional affidavit, my lord, which was filed on 24/1/2020.
24/1.
24/1/2020.
Yes, got it.
Your lordship will see page 6, the communications. I filed a representation to the government, then with reference to your letter on the subject cited above, I am directed request you to kindly resubmit the proposal with the information as to whether the outflow of funds towards the salaries of the working company happens from the budgetary support or not. Then your lordship will see page 8, my lord.
Yes.
Office order issued on 13/9 for partial modification by another office order that I have granted the benefit. 26 employees were given the benefit in 2012 under the existing scheme of slash. That is after adoption of ROP rules of 2010 and introduction of pay band in space scale of pay scale. Medical benefit were given as per AIDC medical rule, which are not the
No,
same.
there might be many, but is it your case that the DGM rank person has been given the next one?
No.
If you come up
No,
with that case, it's good.
No, Lord.
Otherwise, you don't have a case.
So, my lord, we'll have to take a specific instruction. I'm sure
No,
that
Lord.
102 employees
No,
has
Lord.
been given.
Not given.
No, 105 or 100, 200% have been given. That is not the question out here. Here is a case that you come within the rank of a DGM.
Yes, ma'am.
Whether any DGM was given during that period of time to
Means-
the
means after
upgradation.
adoption of ROP.
No, after adoption, after the MOU. And
Yes.
before 13/9.
During that period. I'll have that specific instruction.
So that is the only thing.
Yes,
Then
ma'am.
only a case of discrimination will come.
We'll
Here
have
what has
that,
been
we'll
mentioned
have
that
that,
were
specific
given
instruction.
benefit in 2012 under the existing scheme of SLAS. That is after adoption of ROP and introduction of the pay band in the scale of pay scale. So this you have stated that there was given after it. But whether it was given in the case of a DGM rank,
Well, I have to take that specific instruction because that period I don't have that specific, but I have that.
then
After
that is a case of discrimination. Do you think that there is any other case of discrimination?
Well, that question has never cropped up. Well, it has now cropped
Oh.
up. We'll have a specific answer to that.
She's a lucky one, looks. She's a lucky one who got the maximum benefit.
Oh, come on. You give me 200 rupees, give
No,
me
no, no,
stagnation
that
from
is within the-
2002.
Within the
and now they
payment.
will say
No,
I'm
no, no,
lucky.
It is a payment, within the payment.
Mr.
within
Just for
the
example, let us take the example of an additional director of Department of Agriculture, as I could see from the ROP. His financial upgradation, if he is not being promoted, because there is only post of director is only one, that's also only 200 only.
yes.
It is only 200. You can't help it with that.
No, what the rules has to, rules says it has to be followed. Our case is that all this adoption has taken place after my entitlement. On 13th of September. Prior to that, your lordship has seen their own communication. It has been adopted only of 13th of September.
No.
2013.
Where then, after signing the MOU,
We
where
have
they,
not adopted it. We have not adopted it.
no, where they not bound as per the MOU.
No, MOE is again your lordship will see.
They were bound by
Yes,
the
yes, your lordship will see the,
Therefore, I'm asking
yes,
you
but your lordship will
specific
see the
question.
language. Page 44, your lordship will see.
Of which?
Of the affidavit in opposition. Continuous prescribed. Page 44. First line itself. They have to adopt.
Yes.
Government of Assam Finance Department notification dated 24th August 2012 has allowed the AIDC to adopt the provisions regarding revisions of pay scale. It has said you allow, you have to adopt it.
Adopted.
When did you adopt it?
Yes, we signed.
No. Mr. You see, if you see rule, the Assam ROP rules of 2010, it categorically mentions that these ROP rules shall come into effect from 1/1/2006.
Yes.
And number 2, rule says that unless there is a specific order by the government to adopt, these various institutions cannot do it. It
Yes.
shall not apply.
That's why this has
And
come.
that is why this order is very relevant, by which the government has directed that AIDC can adopt.
Adopt. And when
Because
did
this is
AIDC
a
adopt?
government undertaking.
Malak-
Just for example, I'm telling you, in the cases of Assam Fisheries Development Corporation,
Yes.
there's a specific notification in terms with Rule 2 of the ROP, wherein it says on 7/6/2011, they will do it subject to these other conditions. So this is how it works.
So government has said that permission is granted to AIDC to adopt it. So when did AIDC adopt it? Immediately on signing of this?
Yes.
No, you see, the AIDC cannot adopt
Yes, government has given the permission.
without the specific order of the government.
Yes, this is the order. There's no dispute about it.
No.
It's
Order
of
is
2012.
Order is 24th of August 2012.
Yes, Malak.
That is the order by which the government has directed, yes, you can now implement the ROP
Yes,
2000.
yes.
This
This
is how it
implementation, Malak, your loss will say, this implementation of the government order was adopted on 13/9/2013. And I fall on January 2013. There has to be adoption. Malak. You can't, AIDC, even to change the service rules and all, there has to be permission from the government. And even till date, Malak, that this scale of 7,600, this great pay of 7,600 is not there in the AIDC service rules.
No, it is there. It is there. This one is there, and pay structure is there.
No, Malak, these are not, Malak, the original service rule which I have.
That keeps on changing with the change of every
These are
yeah. Because are you going to say? Are you still saying
Malak,
that you
these
are
are-
only entitled to 10,050?
No,
You are, as of now, in view of that, you are entitled to 30,000 in the come within the pay band of 30,000 to 1,10,000 with rate pay of 17,500.
No, but I
These
was
are all
showing, I
adopted
was
from time
showing
to
your
time.
lordship the service rule, that even the service rule has not been amended. This 7,600 has come.
No, does the
This
service rule
7,600
say?
has come. Now it has
No,
come
no,
on.
let us see whether the service rule say that it has to be adopted. Does it say anything? Without that, yeah, got it. It shall be appointed to a post of honor and shall commence to draw the pay from the date on which he assumes the duties of the post. His pay shall become payable on the afternoon his pay.
In the notification itself, your lordship will find that second paragraph, my lord, of that notification which your lord I have referred now. Any change or revision in pay scale, allowances, parks, or any other service condition of AIDC employees having financial implication and which is not as per the provisions of Assam ROP shall not be made without prior approval of the finance department. So they say that you adopt it and you will not make change anything without the prior approval of the finance department. I'm not disputing that the government, that by the MOU, the permission has been granted by the government.
Which
I
is
say
not,
that this adoption,
Mr.
yes.
Counsel, which is not as per the provisions of the ROP 2010.
Yes, now as per,
ROP 2010 had 12,000 to 40,000 with grade pay of 7,600.
600. But this adoption has taken place on 13/9/2013. They themselves say, my lord, that it is been adopted on 13th of September 2013. Now the specific query is that after the ROP rules and the 2013-39, whether any person of the rank of DGM has been promoted to GM or whether this grade pay scale has been there of 7,600 during this period.
Whether in terms of page 31 of your petition,
yes,
the DGM, other DGMs during this period from the date of entering into the MOU till the date of final, the 13/9, anybody has got.
No,
That
no,
is
we'll
the-
take, no, we'll take that specific. She will be able to give it, my lord. But
It is-
today,
we are not concerned with other 26
Yes, yes,
because
yes.
other 26 would have no relevance.
yes.
It will only have the relevance with the
But
DGM.
we'll take the that specific. We have the list of names of 102 persons, but that period date is not there. Why we have checked the list. We'll take that specific instruction. No problem on that.
Take the when
Your lordship will give a date as per your lordship convenience. madam.
only
Only
convenient.
some accommodation if required, if only there is a clash with outstation cases. Others will not seek for anything.
Yes, Mr. Goswami, you got your instructions. You must be having that instruction. Did
This
you
one.
do anything?
This one.
Please respect.
No, Lordship. Not at all, Lordship. One promotion was made, Lordship. That is some specific reason, Lordship. That was
Because I'm not
clarified.
concerned with others.
Yes,
Because
that was
others does
clarified in
not
my
affect.
affidavit. No,
Because his specific case is on page 31.
yes, no,
31 is a case where there was no adoption of a particular scale. That particular scale of what is the scale? Page 3. See, this scale was not adopted.
12,000 to 40,000. That scale.
No. This scale of 10,307, 10,375 to 16,050 was the scale which was not present at that point of time.
yes,
This came into existence subsequently by incorporation of 1210, incorporation of the ROP,
ROP.
which was adopted on 13/9/2013. So this is the aspect. That is why Mr. Kumar is making the.
no,
He
Lordship.
says that when this particular scale was not there, and here entitlement arose prior to that, can it be done? My specific query is, once you have entered into a MOU, whether you adopt or not, are you not bound?
Yes,
That is one, which I have asked him. And secondly, he makes a case of a discrimination. His case of a discrimination would only arise if in the same rank, because the company secretary has the same rank with the DGM. And being so, whether that during this period, from the date of entering into the MOU till 13/9/2013, was there any person who have any DGM being given the pay scale of the GM in terms with page 31?
Second one, no, Lordship.
I'm asking, this is the query. Then the second one is not there. Then there is a case of the question does not arise for the purpose of
Discrimination, yes, Lord.
the first question, therefore, only remains to that effect as to whether you are bound in view of the MOU, irrespective of you adopt or not, by virtue of the MOU, not to give anything else what other than what is there in the
In
RO.
the, yes, Lord. I will, I come in that answer.
When there is no matter out here that my court is otherwise not like this.
Your
It is
lordship can
always
be
been
busy
that.
with the platinum jubilee celebration.
But what the lawyers are doing with the president, and there,
My lord, your lordship will give a
and the
date.
list is only
My lord, your
11
lordship
matters.
can you give us a date?
When do you want?
Uh,
You are the busy count.
My lord, your
For
lordship will
you,
be,
the 200 rupees does not matter. Yes, tell me.
now to, because in view of the next week celebration, your lordship will also. So I have to ask for it because I was sitting on the morning, any day after vacation.
We'll have it on 20. 20.
Sure. My lord, just a moment.
No,
Because otherwise I'll forget.
Yes,
These are the two specific questions.
yes, ma'am.
And these two will answer everything. If there is a discrimination, number 2 question,
Yes.
then obviously you have to give. As regards the number 1 question, if it is there, you just address on this question.
Your lordship is preoccupied on 21st. Or your hearing day. But the 27, madam, Thursday.
You have seen how many matters are fixed on 27.
Yes, it's
25th
25.
is the matter on 25th of April 2023 for further hearing.
Parted.
But the hearing will be there.
Further hearing. And I'll let me record that those two
Yeah,
aspects,
Lord.
then it will be clear.
Lordship.
Yeah, nowadays it's no problem, my lord. We can look into the live streaming and.
No, it won't be there for this purpose
Yeah.
because
Oh,
1
oh,
month it goes.
It is,
But one heard Mr. P.T. Kaur, the learned senior counsel, assisted by so and so, and Mr. J.K. Gustami, the
respondent
learned
5 and
counsel
6.
appearing on behalf of the AITC. Upon hearing the matter at length, this court have raised 2 queries upon have made 2 queries upon the learned counsels appearing on behalf of the party. Number 1, whether the AITC was bound in terms with the memorandum of understanding entered into with the government of Assam even prior to its adoption on 13/9/2013.
MOE date was 12/9/2012.
To adopt, to take, to be bound by the Assam revision, Assam Services Package Revision of Pay Rules 19/2010. Number 2. Whether during the period from the date of entering into the memorandum of understanding by the AIDC with the government of Assam till 13/9/2013, there was any appointment, any financial upgradation given to those officers holding the rank of the Deputy General Manager. In terms with clause A of the SLES. This is the matter for further. These are the 2 queries. Huh?
Yes. Diploma.
मामला खत्म है और है क्या
My lord, you will still see the prayer, my lord. The page. They want to implement liberalized pension. That is, there is no pension, my lord. There is a provident fund, my lord. And they are getting. Then issue, when she share, my lord, 3 or 4 to 10 lakh. I do not know, my lord, how. That's not potentially award. We have given many others, my lord. We have in the affidavit we have paid. And so far cut-off date is concerned, that is confirmed by the Supreme Court, my lord, cut-off date can be given. Cut-off date.
So primarily the case that
Yes.
these people didn't get the pension.
No, they got PF, provident fund. We don't have pension. Instead, we have got a provident fund. Provident fund scheme.
There is no pension.
No. No, instead, no.
Then what is the basis on which they are asking for?
I do not know, my lord. Earlier, for long back, a very problem, my lord.
That has been pending since 2015. It looks nice. There is no scheme, nothing.
No, my lord. Pension scheme, there are, my lord, there is a judgment of Supreme Court for pension concern. Earlier, while, my lord,
Because pension, if any, has to be on the basis of some statute.
yes, my lord.
The law is clear on that.
PPF we are following, my lord, and PPF they are getting equal amount, my lord, we are giving, and ultimately they are getting.
There's a constitution bench judgment of 1990.
My lord, I'm just giving that, my lord.
Huh? I have it here. I could see from here.
Yes, that was prepared.
The Committee for Protection of Rights of ONGC Employees.
Yes, my lord, that was in the, while it was a commission, my lord, open department.
Yes, Mr. Sharma, what is your case?
My lord, initially in 2013, we had filed a writ petition before this honorable court, saying that we may be treated at par with the post 2007 employees. Now, what they have done, they've created a pension scheme whereby the employees who retired prior to 2007, 1/1/2007, have been left out of the pension scheme, and only employees who are retiring post 2007 have been given the benefits of a pension in the most discriminatory and arbitrary way. We filed a writ petition in 2013, and in that, before this honorable court could hear the matter, the
So
respondents
your
came up-
case is there is some pension scheme after 1/1/2007. Now those people who have retired prior to 1/1/2007 have
been
not
left
been
out.
have been left out.
been left out, because we are the original employees who brought ONGC to what it is today. We worked for 50 years. There's nothing for us. Now, what they did in 2013, they came to the court and they apprise the court that they are having a scheme for the post for the pre 2007 2007 retirees by the name of Asha Kiran. In fact, if your lordship comes to the Annex B of the writ petition,
What are the other phrase, old and all? I hope you are not serious on those.
but we want what we want is we want a uniform pension scheme for everybody.
So your claim here is limited to that.
No, my lord.
Even the gold also, 15 gram.
Gold also, my lord. That was a part of the Golden Jubilee scheme for all the employees who were retired, and that 2 lakhs, and even under this Asha Kiran scheme, what has happened in reality? Only 50% of the employees have benefit. Retired employees have benefit under this scheme prior to 2007. Only 50%. In some year, in 2014, it is 55%. In 2015, it is 40%. Half the employees have not benefited from this scheme. And there was a scheme of payment of 2 lakhs. 90,000 rupees has been diverted. Only 1,10,000 rupees has been given to the employee.
Let us see what is it. First, let us see the liberalized pension scheme. Where is it? Liberalized pension scheme.
This is annexure. Now, before the matter, the Director of Public Enterprises in annexure P1, they have issued an office memorandum. This is office memorandum subject to recommendation of second pay revision committee on creation of a corpus by contributing 1% to 1.5% of profit before tax by central public sector enterprises to take care of medical and any other emergency needs of retired executives and those who are not adequately covered by the pension scheme examination thereof. Now, to the relevant part, the committee recommends that CPSs may create a corpus by contributing 1% to 1.5% of PBT, that is profit before tax, to create a fund in order to take care of medical and any other emergency needs of the retired executives and also those who are not adequately covered by the pension scheme. Now, they have not even spent 0.5% of this amount as directed by the ministry. Number one. We have been
Understood, but tell me, where is the scheme, pension scheme? Where is the pension scheme?
this is one is dated at annexure B3 at page 30. This is one is dated 20th July 2011. This is office memorandum. At annexure D is the page 37. Is a letter by the ONGC to the Welfare Association, my lord. And at the page 38, annexure E is the office order. And the Asha Kiran is at annexure F, dated 15/10/2013.
Yes, so annexure D is a scheme.
Annexure F,
Annexure
page 39. That is Asha Kiran's scheme.
So this Asha Kiran,
It's not
you have retired prior to 1/1/2007. So
this is actually not
you claim to be entitled under this.
this, but our humble contention before the court is that this is not a pension scheme, my lord. This is something to hoodwink us into believing that they're having an Asha Kiran scheme whereas 2000 people post 2007 retirees, they're enjoying a different, enjoying getting full pensionary benefits. We are being left out of they've created this Asha Kiran scheme just like a lollipop, my lord. And that too, this scheme is not being fully implemented. Half the employees have not availed of this.
So you don't want under the Asha Kiran?
No, my lord, we want.
You want under which scheme?
We want whatever has been given to the 2007 post 2007 employees.
Where is the document? There is no scheme.
My lord,
We have not brought the scheme.
this is additional affidavit dated 27 to 2020, my lord,
27.
to 2020.
But
Now, annexure at page 10, annexure 1 starts at page 10. Is for all CPSs, including the post-retiral employees after 2007. And annexure 3 at page 22 is that office order dated 27/10/2017. Relevant part is at page 27, that is superannuation benefit,
where page?
27. That is 11, item 11.
Are you challenging this office memorandum?
My lord, we are not challenging the
If you are not challenging, then how do I give you the benefit? You have to hold that this is arbitrary, not to give you. Because the entitlement of a pension has to be either statutory,
my lord.
although pension is not a bounty, but then also the right has to flow from some statute or something to that effect. If you don't show your right, then how do you get it? And surprisingly, when the earlier matter was there before Justice B.K. Sharma, at that very point of time, it was brought to the attention of the court to the effect that as regards Asha Kiran, And then the matter was closed that you are aggrieved. But at that, prior to that, this document was already there on 26th of November 2008.
My lord.
Then how do you get the benefit of a liberalized pension scheme or this one? Unless there is a challenge to that effect. Have you looked into the judgment of the Supreme Court in the case of DS Nakara? What does it say
My lord, we have
as
just,
regards the cutoff date?
we relied on page 42, my lord, of the judgment. I'll just come to it. At para 42, my lord.
Just wait.
In para 46 also, my lord. If I may read.
Mr. Saivara, the opening of this judgment,
Yes.
I think it's one of the most beautiful openings it has happened.
Right.
Then it refers to Uzli.
Yes.
If I would have done the same thing for the trusted on God, then I would have been more benefited than what I have done for the king. Very nice
Yes.
opening.
Opening is there.
That's it.
Opening is there.
Wait, wait. The internet is slow. Yes. Paragraph 42.
46 also, my lord, may come to 46 via approach.
42. Yes. But in this case, there was a challenge to that cutoff, which is not, however, not here.
The writ petition, we have made a statement that the discrimination between the post 1/1/2007 retirees and pre 1/1/2007 retirees.
But there is no challenge to this or the scheme. In fact, that scheme was never brought in the writ petition. You have brought it in by way of an affidavit. That too in the year 2020. Anyways, let us see if anything can be helped up. If it appears to be undisputable as it does to us, that the pensioner for the purpose of pension form a class, it upward repeated permit of homogeneous But in this case of DS Nakara, both were entitled to the pension. In your case, prior to your retirement, there was no pension at all.
Well, even 2007 cutoff, if a lordship comes to annex a B of the writ petition in that office memorandum of Directorate of Public Enterprises, it's after it is in 2009.
Maybe, but whatever may be, they have done a cutoff of 1/1/2007. It's okay. There were some other people who are benefited.
Hello.
But the question is, in DS Nakara, there is a person who was already entitled to pension because of the putting that particular date. It had a person has been given a particular date, but thereafter, if you see another judgment of T. Sampath, there the Supreme Court has categorically mentioned to the effect that it is the executive who has the absolute wisdom in fixing the date. The cutoff.
My lord, if my lord permits me, my lord may kindly see 2020 14 SCC 625. This is all Manipur Pensioners Association versus the state of Manipur.
I've seen it here. Given
2020 14 SCC at 620.
All Manipur Pensioners Association.
lord.
Yes. What does it say? Paragraph. Tell me.
7.3, it has discussed the Nakara case. Now, my lord,
Then here also both were entitled to the pension. That is also the amount is only the difference is only the cutoff. Like in Nakara, a person retiring prior to that would be entitled to 8,100, and in after that per annum, and the person retiring after the cutoff date would be entitled to 12,000 rupees. Here also it is the same thing. If you see the paragraph out here, more particularly paragraph number 2 starts.
at para 8, there is page 637 on the same judgment.
Where? The judgment paragraph?
8.
Yes, even otherwise.
Even otherwise, on merits also, we are of the firm opinion that there is no valid justification to create two classes, with one who retired pre-1996 and the another who retired post-1996 for the purpose of grant of revised pension.
Revised pension.
You know,
There,
there's no
that is
pension.
why you are saying about classification. The question of classification, that is why the Supreme Court, even in Nakara and all these other judgments categorically mentioned that you cannot have a further classification as regards the person who comes within the ambit of a pensioner. But the first and foremost, whether you are a pensioner, because what you are asking, if we are to imply, then in all cases, this should be an unending matter. It will be huge expenses. Now you are asking here, there might be other people also where also these people will be entitled to. All persons retiring prior to 1/1/2007. And if that same principle applies everywhere, it will have a far-reaching consequences.
1% ONGC is a rich corporation.
Huh?
ONGC is a rich corporation, my lord, with all respect. Now, my lord, 1% or
Rich and
1.5%.
poor, it is not for this court to take into account.
1 or 1.5% comes to around 30,000 crores or 35,000 crores.
No. That is 1.5% is for the purpose of medical.
After
Medical
deducting the
emergency.
medical,
That is a medical injury for which they may have a scheme. That is whether they have a, I think you must be having a scheme for that.
That is there.
So that is there. They are going to have that, whatever may be that is there. But to get the pension out here without the pension at that point of time when he was existing. Yeah, therefore in Nakara you say a pensioner, once he becomes a pensioner, you should not subdivide it, that a person retiring prior to that shouldn't have been. And that is what has been followed.
No, because initially, my lord, when the ONGC adopted the Central Pension Act, we the employees were not given the option to adopt the pension or the CPF. That option was not given to us. It was imposed upon us. That pension was not given to us. That the option of opting for a particular pension was not given to us.
Don't you think that will be, what you call, bringing up things which are already stood buried out there? Now,
Now our grievance is, my lord, we have no pension at all. We have left to fend for ourselves.
how can anybody help you on that? If they were you at that point of time in your service condition, there was nothing. Now they have Asa Kiran thing.
Yes,
Now with that Asa Kiran, if you are not being given the benefit,
No, my lord.
then it's a different aspect.
Yes,
of the
we are not
matter.
given the pension.
That for that purpose, this court can look into it. But not as regards this pension up to more particularly when you have not challenged the classification.
That benefit, my lord, we have paid in the affidavit, my lord, page 4, that is 1.5. We have given.
No, about that Asa Kiran.
Asakran we are giving.
So Asa Kiran, these people has to get the benefit because that is your
That we-
policy.
Yes, yes. That we are giving, my lord. They cannot point out, my lord. If they point out something, my lord, they shall take it.
That is not being implemented.
Hmm?
We are not getting the amount. More than half the employees, and the employees also who are getting the amount. People are being paid 90,000 and 1,10,000. 90,000 is being diverted siphoned off. We don't know where it has gone. We haven't received it. And that too about, I'm talking about 40 or 50% of the employees. Half the employees haven't got. That's
No,
why they
let
also-
us see what does Asa Kiran show. What is the Asa Kiran? Yes, got it. Annexure 5, F, page 39. Former regular employee of the government who superannuated mayor on health grounds from the service prior to Iman. Former health ground who suffered permanent Iman. Surviving spouse of so while doing it. That 15. Certificates shall be submitted to the respective. But in case what are the benefits? Let us see what are the benefits. What are the benefits out here? The amount of finance to be provided shall depend upon the nature and magnitude of emergency situation being faced by the effective eligible individual. An indicative exhaustive list showing the permissible ceiling for various kinds of emergency situation is expended.
more specifically mentioned in the financial support.
Asa Kiran is only for meeting the emergency needs of a retired employee or their surviving in case of a. And the maximum amount is 2 lakhs.
2 lakhs. 2 lakhs.
Of which we are paid only half.
Huh?
Of which we are paid only half.
No, no, no. You are not paid your half. You are not going to be entitled unless you apply.
When we apply, when we get.
No, you will be only given the maximum ceiling is 2 lakhs. You
Yes,
may keep on applying. You can't get more than 2 lakhs.
Yes,
That's
yes,
it.
my lord. That is correct. But we are not getting not even half sometimes.
No, if you are not, have you brought in any instance that you have applied for that and you have not got it? And how can that be maintained by way of an association?
Whatever we could, we have filed RTI
Because a person would not normally get 2 lakh. The maximum a person throughout his life, or his spouse, or the surviving people can get on account of emergency is 2 lakhs. Nothing more than that. And if there is no emergency, if you have an income more than 10,000, you don't come within the ambit. Have you challenged Asakirun that it is not in terms with 1.5?
No, because we have not challenged, Asha Kiran is not actually a pension scheme.
Understood. First and foremost, you are not entitled to the pension because at that point of time you have retired, there was no pension. Now let us go to the question of Asha Kiran. Asha Kiran only gives 1.5 of emergency. It won't be otherwise. And the emergency maximum limit is 2 lakhs. Now, that may not be good for you or may not be feasible for you. So, understood. But for that, this court's power under 226 is limited, taking into account the economic viability of these people, which they are the best to understand. One thing I don't understand, kindly come to pay Annexure D, page 37. This is a letter by the manager HR to Durga somebody.
To the president of the welfare society.
Please refer to your letter dated demand forwarded by the Ministry of Finance.
By the Prime Minister's
For to retired employees. ONGC being considerate to the cases of retired have designated a draft scheme to be given to give some financial benefit to AR who separated on or before to take care of emergency. Proposals to this effect have already been submitted to market. So this became Asakiran.
I know. Subsequent.
Mr. Sharma, you have to develop your case better, not in this manner. You have to develop your case to the effect that this court can issue a writ to the effect that these people, the ONGC should frame something. You can develop your case in that. As of now, this court doesn't see any.
May allow me develop it.
Okay, we'll allow you. But as of now, there is nothing near it. What about the gold? You're not giving? Huh? Hey, there is some scheme to that effect as I could see from Annexure B1 or something.
That is the Golden Jubilee.
Huh? Yes, Golden Jubilee, these people have gone out there. You have to those people who have reached 70 years or 80 years to the effect. You are getting some medical thing. Are they getting anything on medical? Nursing care?
Yes,
Me-
well, that they are getting.
Those they are getting.
My lord, if you losses see my FTP, my lord, that is 6, 10, from 15.
That is what I am looking into.
My lord. So paragraph 6, my lord, we have given all that. And all those schemes we have annexed.
There was no CPF scheme.
No, ma'am. There was a CPS scheme, but we are not given the option, opportunity to choose between either of them. It was imposed upon.
Impose upon you what?
Central pension.
Huh?
Central pension scheme. We have made a, the repetition of my lordship comes to this page.
No, you were given central pension scheme.
Central provident fund.
No, sorry.
Oh,
my-
provident
oh,
fund.
I'm sorry, a provident fund, not the
EPF.
pension scheme. We are not given a pension.
You got the EPF.
EPF,
EPF gives a pension, na?
no, ma'am.
Yes, EPF who gives a pension. Doesn't it, Mr. Chahwala?
Well,
As far as I know, EPF also gives a fund pension.
my lord, in CPF, my lord, they contribute some amount, equal amount is
They are
contributed by
contributory.
the
Yeah.
management, my lord, and they get. My
That is given as a pension. As a,
lord, because they can keep it in the bank also, my lord, in this scheme, and yearly they will get it.
that is
my
how
lord.
it is.
That they can do it, my lord. That is not pension, my lord, but this is different scheme.
No, yesterday
sometimes-
I was taking a matter.
Yes.
Not yesterday, day before yesterday. I was taking a matter where the question was
Yes.
as regards a person who is in central pension scheme, central government pension scheme, can he adopt the EPF? Because what happened, there was a problem which arose. The Airport Authority of India, prior to these airports and all being taken over, these employees were under the EPF. And then when the Airport Authority of India had taken it over, they got their central pension. Now what was happening, they were getting both pensions. Then the government says that a person can't get two pensions. One under the EPFO and the under the central pension. Then the central pension stopped. The EPFO was there. Then the matter was going on. In the meantime, the Madras High Court had taken a decision in respect to Tamil Nadu's case, servicing pension rules, and said that once you surrender the EPFO, then you will be entitled to the pension as per the Tamil Nadu service. And while doing so, you have to give the entire EPFO money, whatever you have got, get it back, or it can be deducted from your area pensions, from the area pension which you would have otherwise got. That matter I was considering another
But
matter
here
to
in
the
the
effect.
CPF means contributory provident fund.
Huh?
Contributory provident fund.
Okay,
But
not
it is
the other one,
No, no.
EPFO.
It is contributory provident fund because they contribute, my lord, so 50 rupees they contribute, management give 50 rupees and it keeps, my lord.
Oh,
Then-
this is similar to the tea gardens.
Yes. Well, it is kept in the bank, my lord, that is their, as per their requirement, they take it every year.
So nowadays, which you have new pension schemes are, which are there?
Not-
New pensions, not
No,
here.
not-
Now, all these new pension scheme, which we have the government of India as well as our state government, You are to pay, in state government, you are paying 10 rupees. The government is going to pay 15 rupees. And that goes, and at the time of retirement, you are given 40% of that, and the rest 60 is kept out there. So that is not what was there at that point of time. Very bad. But Mr. Sharma, you have to better your case. You don't have a case at all. Luckily, madam, luckily you got of your senior. Otherwise, I would have the matter would have been dismissed at your hand. Yes. You want some time?
My lord, make me an opportunity.
Or I should dismiss it right now.
The retired people, so my lord, give me an opportunity.
Mr. Sama, right, from morning to evening for the last 6 weeks, I am only taking case of retired people only.
I understand.
At Mr. R. Sharma, the learned senior counsel, assisted by so and so. And Mr. T. N. Tribal, the learned senior counsel, assisted by N.A. Singh. After hearing the matter, the learned counsel appearing on behalf of the petitioner submit that he would further like to seek an accommodation. The learned counsel for the petitioner submits that he would also he would seek an accommodation and to see as to whether any other points can be met out in the instant writ petition. Taking into account, let the matter be listed on 25th of April, 2023 for further consideration. Okay. Giving you an opportunity.